Hello everyone, a very good evening. So today we have to practice questions from our Module C, and Module C is important. Some of the units are extremely important like the Surface Act, the IBC, the Recovery of Debts Due to Banks Act. These acts are very important. So we'll be covering questions mostly from these acts. And we have case studies also because case studies are also asked from our Module C. All right, so try to be active, try to answer the questions, and yes, so let us start. Let us start with the first question from our module C. Okay, so who is the appellate authority as defined in the Integrated Ombudsman Scheme of 2021? So, what is the Integrated Ombudsman Scheme? The three ombudsman schemes, the ombudsman for bank, NBFCs, and the digital payments have been merged into one, the RBI Integrated Ombudsman Scheme, right? Now, wherever the customer faces a complaint, a deficiency in service from a regulated entity, and they do not get a satisfactory response from the regulated entity within 30 days, they can make a complaint to the ombudsman. The ombudsman will try to resolve the whole issue within 60 days. If the complainant is still not satisfied, or if say let's say the regulated entity is not satisfied, they can make an appeal to the appellate authority, which is the executive director in charge of the department of RBI, which is administering the scheme, the CEPD. Okay, so that is the appellate authority, the executive director in charge of the department of RBI administering the scheme. Okay, a person can themselves, they can on their own make a complaint, or they can have an authorized representative other than an advocate. The authorized representative cannot be a person of law, they cannot be an advocate, except when the advocate himself faced this deficiency in service. Okay, Sanjeev, a small business owner, had issues with ABC Bank concerning a loan rejection. He filed a complaint with the ombudsman, arguing that the bank's commercial judgment was unfair. However, ABC Bank defended its decision, stating that the loan rejection was based on internal policy and risk evaluation. Meanwhile, Sanjeev had also filed a similar case in court seeking the damages. The ombudsman reviews the complaint and must decide whether the complaint is maintainable under the clause 10. So the clause 10 states the various complaints that are maintainable and those are non-maintainables because the complaint was filed without any legal representation. So what should be the correct answer? If you remember, we have studied the various complaints that are non-maintainable. This section, clause 10, circumstances where a complaint is non-maintainable. Wherever there's a dispute between regulated entities or a dispute involving the employee-employer relationship of a regulated entity, dispute where the action is initiated in compliance of the orders stipulated by RBI, grievances where there's a dispute between vendor and a regulated entity, and wherever there's a commercial judgment. So the complaint will be rejected. This person, Sanjeev's complaint will be rejected because a complaint against the commercial judgment is non-maintainable under the clause 10. Commercial judgment means any advertisement. A complaint against any advertisement, promotional strategy, this is non-maintainable. That is why it will be rejected. Okay. What is the maximum compensation amount that the ombudsman can award according to the clause 15 of the Act? The maximum compensation amount. Is it rupees 20 lakhs or the consequential loss suffered, whichever is lower? The total financial loss suffered by the complainant, rupees 10 lakh, the amount involved in the dispute plus the consequential loss. So, what is the compensation? What is the compensation? So the whole process, let us recall once. When the ombudsman receives the complaint from the customer of the bank, of the regulated entity, they will send summons to the bank to produce certain documents, produce the information. Then, on the basis of the records placed, the decision will be taken by hearing both the parties, right? After hearing both the parties, the complainant as well as the defendant, the ombudsman will then announce the award, pass the award, and the compensation will be an amount which is 20 lakh rupees or the consequential loss suffered, whichever is lower. So the ombudsman cannot give an award more than 20 lakh rupees. Maximum is 20 lakh rupees, right? And it is exclusive of the amount involved in the dispute. Plus, plus there is also another clause for compensation for mental anguish or the trouble that the complainant had to go through, the complainant's time, expenses incurred, harassment. For that, what is the award that can be announced by the ombudsman? It is 1 lakh rupees. Okay, so this award plus 1 lakh rupees for the mental anguish. Okay, try to answer. Please try to answer the questions. What happens if the complainant does not furnish a letter of acceptance of the award within 30 days of the receipt? Now, when the ombudsman issues this award, including the compensation to be paid, a copy of the award is sent to the complainant as well as the regulated entity. Okay, and the complainant has to give a letter of acceptance that yes, they are satisfied about for whatever is given in this award. Okay, but if this letter of acceptance is not given, no, the award will lapse and becomes of no effect. The ombudsman will not extend it for further 30 days. No, within a period of 30 days from the date of receipt of the copy of the award, they need to give a letter of acceptance. All right. Then, when they give this letter of acceptance, the complainant, the customer of the regulated entity, then the regulated entity has to perform the action or perform their duty, complete whatever has been given in the award, pay the compensation within 30 days from the date of receipt of the letter of acceptance. Obviously, this will not be applicable if any of the party they have made a complaint to the appellate authority, appeal to the appellate authority, then this 30 days time will not be there. Okay, appeal has to be made within 30 days of receiving the notice, receiving the copy of the award within 30 days. Okay, so the correct answer will be B. The award shall lapse and will be of no effect unless the complainant furnishes a letter of acceptance of the award in full and final settlement of the claim to the regulated entity concerned within 30 days. Okay. Under the MSME Development Act, the MSMED Act 2006, the expression day of deemed acceptance includes which of the following situations? The day of actual delivery of the goods or rendering of services, the day on which written objections raised by the buyer within 15 days are removed by the supplier, the day on which the buyer issues a purchase order, the day of deemed acceptance where no objection is raised within 15 days. So, which of these situations refer to the day of acceptance? What should be the correct answer? When we are talking about the Micro, Small and Medium Enterprises Development Act, it basically protects the MSME seller. Wherever the MSME seller has provided goods, sold goods to the buyer, and the buyer does not make a timely payment, that is, the buyer makes a delay in the payment, the MSMED Act is there to protect them. D, 1 and 4. Day of deemed acceptance. Anyone else? Everyone who's present here, try to answer the question. What should be the correct answer? The first statement is true. Yes. And the fourth statement, however, is not true. See, recall once again the day of acceptance. The day of acceptance will be when the goods are delivered and they are accepted. Okay, they are accepted. And if no objection is raised within 15 days, then also it will be the day of deemed acceptance. Okay, it will be the day of deemed acceptance, right? Day of acceptance means either the goods are accepted, the actual delivery, or the day, if let's say when the goods are delivered and the buyer raises a complaint, then on the day on which this complaint is resolved will be known as the day of deemed acceptance, day of acceptance. If no objection is raised, then the day of delivery is known as the day of deemed acceptance. Deems means understood, implied, right? Again, once again, let us repeat. Let's say the goods were delivered by the MSME seller to the buyer, Mr. X, on 10th of December. They are delivered today. Now, either what will Mr. X do? Mr. X will raise objection if they're not satisfied. This they have to do within 15 days. So within 25th of December, they need to raise an objection. Let's say they raise an objection on 20th, on 20th of December. Then the objection was resolved. The problem was resolved by the seller on 27th. Okay. So these 2 days will be known as the day of acceptance, either when the delivery is made or on the day when the objection is resolved, when the problem is resolved. Day of deemed acceptance will be if no complaint is raised by the buyer. No complaint is raised by the buyer. Okay, so the correct answer should be A, 1 and 2. All right, 1 and 2. Case study questions will be asked from here. Can be asked. Case study questions might be asked from here. So remember, the day of actual delivery or where any objection is made in writing, then the day from on which the objection is removed. This is the day of acceptance. Day of deemed acceptance means where no objection is made in writing by the buyer. Okay. Mehra Industries, a small manufacturing firm, supplies raw materials to Omega Private Limited under a formal contract, agreeing that payment will be made within 40 days of delivery. However, Omega Private Limited fails to pay within the agreed time frame, prompting Mehra Industries to demand compensation. As per Section 16, Mehra Industries now seeks interest at 3 times the RBI's bank rate for the delayed payment. Meanwhile, the Omega Private Limited argues that their internal policy allows them up to 60 days for the payment. So, why is Omega Private Limited their argument incorrect? Because the company must follow its internal policy over statutory requirements. They should have made the contract of 60 days because the payment terms cannot exceed 45 days from the acceptance, because the delayed payments are exempt from legal penalties if justified, because the MSMEs cannot demand payment. Okay. Why did we study the concept of day of acceptance or day of deemed acceptance? Because from the day of deemed acceptance, within 15 days the payment should be done. So either on 10th of December when the goods are accepted, or on 27th of December when the objection is removed. From this day we will count 15 days. Within this the payment should be done by the buyer, or otherwise this is now known as the appointed day. Okay, appointed day. After 15 days this is known as the appointed day. However, if there's a separate agreement between the buyer and the seller, they can provide additional time, more than this 15 days time, but maximum up to 45 days. Even if there is an agreement between the buyer and the seller, it cannot be more than 45 days. And here, if the payment is not done on the appointed day or whatever is decided, then the buyer will be liable to pay interest for every day the delay continues. Interest will be paid at compound interest with monthly rest, an amount which will be 3 times the bank rate specified by RBI. Okay, 3 times. 3 times the RBI's bank rate. So the correct answer will be B. Okay, the payment terms cannot exceed 45 days from the acceptance, even with a contract. So where any supplier supplies any goods or renders any service to any buyer, the buyer will make payment on or before the date agreed upon between them. And if there is no agreement, then before the appointed day. And even if there's an agreement, the agreement cannot be more than 45 days, maximum 45 days to make the payment. All right. And appointed day is when the payment has to be done within 15 days from the day of acceptance or deemed acceptance. Okay. Under the section 15 and 16 of the Act, which of the following statements are correct regarding the payment obligations and consequences for the delay in transactions involving the MSME suppliers? If no written agreement exists, the buyer must pay by the appointed day, which cannot exceed 45 days from the date of acceptance or the deemed acceptance. Even if the supplier has waived interest contractually, Section 16 mandates liability for compound interest with monthly rest. Section 15 permits parties to agree in writing to extend the payment beyond 45 days. The applicable rate of interest is triple the RBI's notified bank rate. The trigger for interest calculation depends solely on when the buyer acknowledges the invoice. Go through the statements and answer which of these statements are correct. A, C and D, A, B and D, B, D and E, or A, B and E. Which of these statements are correct regarding the payment obligations and consequences? Which statements are correct? The first statement says that if there is no written agreement, the buyer must pay by the appointed day, correct, which cannot exceed 45 days. No, the appointed day, if there is no written agreement, cannot exceed 15 days. So by 15 days from the day of acceptance or deemed acceptance, the payment has to be done. This statement will be incorrect. Okay. Even if the supplier has waived the interest, right? If even if the supplier in their contract, they have waived the interest contractually, still the liability for compound interest will be paid if it is an MSME supplier. So this statement should be correct. No, actually A should also be true, right? A should also be true. If there is no written agreement. Okay. If there is no written agreement, it should not exceed 45 days. If there is a written agreement, yes, okay. Even if the supplier had waived the interest, this is also true. The section 15 does not allow to extend the payment beyond 45 days. No, maximum 45 days. Either the appointed day, which is 15 days, or if there's an agreement, then maximum 45 days. So C will be incorrect. The applicable interest is 3 times the RBI's bank rate. Correct. Then the trigger for interest calculation when the buyer acknowledges the invoice. No. When there's a delay beyond 15 days, from that day onward, from the 16th day, we will start calculating the interest. Right? So where a buyer fails to make payment to the supplier, the buyer will be liable to pay compound interest with monthly rest to the supplier from the date immediately following the agreed upon date. Immediately next day. So immediately next day, the interest will be calculated. So the correct answer should be A, B, and D. Option C. Yes. Option C will be correct. A, B, and D. Okay. Statement C is incorrect. We cannot go beyond 45 days. And E is incorrect. The delay in payment triggers the calculation of the interest rate. On what constitutional grounds did the Delhi High Court initially declare the Surfaci Act unconstitutional? So, when the Surfaci Act was enacted in 2002, it was declared unconstitutional by the Delhi High Court. What was the ground for it? It violated the principle of separation of powers. It was found to be in conflict with the Article 14 of the Constitution. It failed to provide adequate protections for the borrower. It infringed upon the rights of the banking institution. So, what should be the correct answer? What should be the correct answer? A. You are saying A. A is violated the principle of separation of powers. It did. This was one of the reasons, but the main reason that the Delhi High Court said was that it was in conflict with the Article 14. Article 14 is a constitutional right, equality before the law. Equality before the law. And the Delhi High Court said that if special courts are created for the banks, it will give privilege to the banks over the other public. So it was declared unconstitutional by the Delhi High Court. Right? It was declared unconstitutional because it violated the Article 14. But later on, the Supreme Court held that it was constitutionally valid. The act is constitutionally valid. It is not violative of Article 14. Just one of the sections is violative. Which section? Section 17 of the Act, which required that a pre-deposit of an amount 75% of the debt amount should be pre-deposited. So if the borrower is aggrieved by the action taken by the bank, any action taken by the bank, they can make an appeal to the DRT, but first they have to deposit 75% of the debt amount. This was declared unconstitutional and the section 17 has been removed. So the borrower can make an appeal to the DRT without depositing anything. Right? So the correct answer will be B. The constitutional validity of the act was challenged by the Delhi High Court Bar Association before the Delhi High Court. It decided the law to be unconstitutional, void, and hit by the Article 14 of the Constitution. What you are saying, A is actually the meaning of it. True, it violated the principle of separation of powers. It is true. The court said that judiciary and the executive should be kept separate. Why would the government be involved in the law cases? Right. But the main reason for declaring it unconstitutional was Article 14. This was the explanation of it. All right. Yes, the High Court said that civil courts are directly under the control and superintendence of the High Court and they will be deprived of their jurisdiction. It is against the theme of the constitution and independence of the judiciary. So this is an explanation. All right. Okay. If they give you a multiple selection question, then you will select both. But right now it is clearly asking you on what constitutional ground. What constitutional ground? So the Article 14 of our constitution. Okay. Which of the following statements best describe the legal and functional architecture of securitization in India? Securitization under the SARFAESI framework allows ARCs to acquire financial assets, including secured debts, and issue security receipts to the investors. The process converts illiquid banking assets into tradable instruments to be placed in the financial markets. Prior to SARFAESI, Indian law had no specific provision enabling the transfer of mortgaged back or security backed claims. On acquisition, the ARCs hold mere custodial rights and the originating bank remains liable for the risk. So, which of these statements are correct? What happens in securitization? The banks, they prepare a pool of asset, a pool of NPAs, homogeneous asset. They transfer it to the ARC. The ARC make an immediate payment. These pool of assets are completely acquired by the ARC. The pool of assets are completely acquired by the ARC. This means that the risk, collection of the underlying debt, everything is passed on to the ARC when they issue security receipts using this pool of assets. That is the pool of assets, they are the underlying. The security receipts are the derivatives, right? They are deriving its value from the underlying pool of asset. From where will the ARC make payment? To these investors who are investing in the security receipt. The ARCs will make payment from the EMIs that are paid by the borrowers, or they will sell the securitized asset and they will make the payment to the investors. Okay, so the ARC, they are transferred even the risk and collection of the underlying debt. So fourth statement is incorrect. 1, 2, and 3. Okay, the ARC steps into the shoes of the lender and the transaction is without recourse to the originator who is the lender. Okay, without recourse. The ARCs, they take over the complete risk. Okay, read the statements very carefully and then answer these multiple selection questions. Which of the following conditions must be mandatorily satisfied by a company before commencing securitization or asset reconstruction activities? Basically, the requirement for an ARC, any company, they want to function as an asset reconstruction company. What is their requirement? Submission of an application in the prescribed format for registration to the RBI, maintenance of net owned funds not less than 2 crore or higher notified by RBI, holding of equity shares by at least one scheduled commercial bank, clearance of at least one successful acquisition proposal before applying for registration. So, which of these statements are true? 1 and 2, 2 and 3, 1, 2 and 4, or all of the above. So, to perform as an asset reconstruction company, licensing requirement is there. Okay, they need to get registration. They will submit an application to RBI in the prescribed format, and the net owned fund will not be less than rupees 2 crores. Right? However, the statement 3 says that holding of equity shares by at least one scheduled commercial bank, not necessary, not necessary. And the statement 4 says that clearance of at least one successful acquisition. How? Before doing any securitization or reconstruction process, they need RBI certification, registration. Without that, the ARC cannot commence or carry on the business. So, how will they complete one successful acquisition before applying for registration? Not allowed. Without registration, they cannot carry on, they cannot start the business of asset reconstruction. The correct answer will be A, 1 and 2 only. 1 and 2 only. A company must be registered prior to undertaking any acquisition. All right. So 1 and 2 only will be correct. Okay. Which of the following statements correctly reflect the statutory implications of giving or not giving notice of asset acquisition by an ARC? So this basically is if the bank is transferring their assets, the loans, NPAs to the ARC, do they need to give a notice to the borrower or not? If notice of acquisition is given to the obliger, obliger is the customer of the bank, the borrower, future payments must be made directly to the ARC for the valid discharge of liability. If the obliger is a company, filing notice with the ROC is always mandatory upon asset acquisition. Where the notice is not given, any amounts paid to the originating bank must be held in trust and forwarded to the ARC. Giving notice to the obliger is a statutory precondition for enforceability of transferred asset. Basically, you need to decide whether giving notice to the borrower is compulsory or not. And if the obliger is a company, whether giving notice to the ROC is compulsory or not. What will happen if the notice is given? What will happen if the notice is not given? So if the bank gives notice to the obliger, the customer, all the EMI payments will now be made directly to the ARC. If no notice is, however, given, if no notice is given and the bank receives any payment from the customer, they will hold it on behalf of the ARC and they will have to transfer it to the ARC. If any EMI payment, interest principal is made by the borrower, the bank will have to transfer it to the ARC, right? However, giving a notice to the obliger or giving a notice to the ROC is not mandatory. It is not compulsory. All right, giving a notice is not compulsory. All right, giving of notice is completely optional. In case the obliger is a company and the creation of the charge has been registered, then also giving the notice to the ROC is optional. It is not compulsory. However, if the bank, the financial institution, gives the notice to the obliger, then notice to the ROC is also required. If the customer is a company and the bank has given a notice of the acquisition to the company, they also need to give the notice to the ROC. Otherwise, it is completely optional. There's no obligation, it is not mandatory, it is not a precondition for enforceability. All right, so the correct answer is B, 1 and 3 only. According to the section 33 of the SARFAESI Act, which scenarios lead to liability for the company officers, the ARC officers? If the officer directly commits an offense, if the officer abets an offense, abets means helps, if the officer is committed with the if the offense is committed with the consent or connivance of the officer, if the officer is unaware of the offense. So in which of these scenarios will the officer of a company will also be held liable? They will also be liable to pay the penalty. Everyone who's present, try to answer this question. I think this is easy. This question is easy. Basically, the RBI imposes penalties for the non-compliance of directions that are issued by the RBI. Okay? If any person contravenes, they try to contravene or helps the contravention. So, yes, the correct answer will be A, 1, 2, and 3. The officer of the company will also be liable, okay, when the penalty is imposed. But if they are able to prove, if they're able to prove that they had no knowledge about the contravention or they had taken due care to avoid the contravention, then the penalty can be waived off, their liability can be waived off. Otherwise, not. Okay? Yes, so the correct answer will be A, 1, 2, and 3. Which of the following are valid statutory measures that a secured creditor may adopt under the SARFAESI if the borrower fails to discharge liabilities? So, whenever the asset becomes non-performing, before initiating the SARFAESI powers, before initiating the SARFAESI powers, that is attachment of the property, selling of the property, the secured creditor has to give a notice to the obliger, the borrower. Notice demanding payment of the full money, full mortgage money, principal and interest. And serving the notice that if not discharged, then such and such action can be taken. So, what action will be taken by the secured creditor if the borrower fails to discharge their liabilities within the notice period? Take possession of the secured asset and transfer it by the way of sale, lease, or assignment for recovery. Take over the management of the secured asset, including authority to transfer or lease it. Appoint a manager to oversee the secured asset in their control. Demand direct payment from the third parties who owe money to the borrower. So, what actions can the bank take in the enforcement of security interest? So, the creditor can enforce the security interest created in their favor without the intervention of a court or tribunal, but giving notice by the secured creditor to the borrower who has defaulted in making the repayment, right? This notice will be given asking the borrower to discharge their liabilities in full within how many days? Within 60 days of the notice, when the notice is sent. Failure to do so by the borrower, now the secured creditor gets further rights. What can the secured creditor can do? The secured creditor can uh, take possession of the secured asset. Yes, they can transfer it, assign it, sell the realized property, take over the management, appoint their own officers, then appoint any person to manage the security assets. They can also, let's say, any person, our borrower is A, any person B owes money to A. The bank can also direct this person B to directly make payment to the bank. And this person B will have to now follow it. Okay, this person can be there, or let's say the insurance company is there, anyone who has to pay money to the borrower. So the correct answer should be all of the above. All of these actions can be taken by the secured creditor. They can take possession of the secured asset, take over the management of the secured asset, appoint a manager to oversee the secured asset, demand direct payment from the third parties who owe money to the borrower to the extent of the secured debt. If this third party is summoned, then they will have to comply with it. If failure to do so, now they will become a party in the default. Penalty will be imposed on them. All right? Yes. So the correct answer will be D. With reference to the enforcement and appropriation under the SURFACE, which of the following statements are correct? So when the secured assets they are sold, where the security, not secured asset, but where the security, the assets are sold. How is the proceeds applied? Sales proceeds are first applied to the cost and preservation charges, next to the secured dues, and then to the other entitlements. Government dues such as taxes and cesses override the secured creditor's right in the distribution. In joint financing arrangement, the possession can be enforced only with the consent from secured creditors representing not less than 60% of the total outstanding. If the borrower repays the entire dues and cost before the notified sale date, the secured creditor cannot proceed with the sale. So, which of these statements are correct? This is also a very simple question. Try to answer 1, 2, and 3, 1, 3, and 4, 2, 3, and 4, or all of the above. If you remember the waterfall arrangement, then you can answer this question correctly. The correct answer C. The government dues such as taxes and cesses override the secured creditor's rights. No, the sales proceeds will be first used to pay the liquidation charges, then the secured creditors' dues, and then the government's rights, unsecured creditor, any shareholder, then they will come. So the correct answer should be 1, 3, and 4. 1, 3, and 4. B should be correct. Yes. Second statement is incorrect. The government dues, they get priority after the secured creditors. After the secured creditors. Okay? The secured creditors, they have priority over the government dues. All right. So the correct answer will be B. 1, 3, and 4. What action does the central registrar take upon receiving intimation of full payments from the secured creditors? Orders that a memorandum of satisfaction be entered in the central register, seeks approval from SEBI for recording the payment, freezes the borrower's assets until further verification, requires a borrower's written consent before updating the records. So, when the secured creditor or the borrower, they give this information to the central registrar that the amount of debt has been paid, it has been satisfied, what will the registrar do? What is the action taken by the registrar? The ARC or the secured creditors, if the payment is done in full, they will give intimation to the central registrar of any security interest, right? Within 30 days from the payment or satisfaction, they need to give this information. On receipt of the intimation, the central registrar will order that a memorandum of satisfaction shall be entered. If, however, if, however, the concerned borrower gives an intimation that I have made the full payment, but you have not recorded the satisfaction memorandum, then the central registrar will give summon notice to the ARC or to the secured creditor to show why the satisfaction should not be recorded. If no cause is shown, then the registrar will order a memorandum of satisfaction. If a cause is shown, then this will be recorded and the borrower will be informed about it. Yes, so if the ARC or the secured creditor, they give this information about the satisfaction, the registrar will order a memorandum of satisfaction to be entered. Correct. If, however, the borrower gives this notice, first the registrar will ask the ARC or the secured creditor whether the settlement has actually been done or not. Okay. Which of the following statements are true regarding the appellate remedies under the SARFAESI Act? Appeal before the appellate tribunal must be filed within 30 days from the date of communication of the DRT's order. For filing the appeal, borrowers must pre-deposit 50% of the debt. The tribunal can reduce it to 25%. Appeals may be entertained against consent orders passed by the DRT. If the DRT fails to dispose the borrower's application within 60 days, the borrower may directly approach the Supreme Court under Article 32. Go through the statements and answer this question. What should be the correct answer? What is the appellate powers? Article 32 again is a constitutional right. Sorry, not a constitutional right, fundamental right. The citizens can directly approach the Supreme Court to enforce their fundamental right. Okay, habeas corpus, mandamus, prohibition. So answer this question now. Wherever the borrower or the bank, they are aggrieved by the award passed by the DRT, they can make an appeal to the DRAT, not to the Supreme Court directly. No, the Supreme Court will be approached only when the questions of law are involved and against the order of the DRAT, only if the question of law is involved. So the fourth statement will be incorrect. Similarly, when the award is passed, the order is given by the DRT with the consent of both the parties. Then also appeal cannot be made. Right? So the correct answer should be 1 and 2 only. C. 1 and 2 only. Okay, so what is the whole appellate procedure? Whenever, let's say, a case was referred to by the bank to the DRT, they are not themselves taking action under the SARFAESI, rather they want it to get resolved by the DRT. right? The DRT, after hearing the both the parties, they pass their order. If the customer or the bank is not satisfied, then within 30 days they can take it to the DRAT by depositing 50% of the debt claimed, decided by the tribunal. Okay. Another situation when the bank takes action under the SURFACE without the involvement of the DRT, let's say through an ARC or selling the asset by themselves, then also first applicant to the DRT will now be the borrower. So borrower can be the first applicant to the DRT when the banks are enforcing the SURFACE right. Okay, the borrower cannot take the case to any civil court. They must make an appeal to the DRT and further to the DRAT. Making an appeal to the DRT, zero deposit is required. Making an appeal to the DRAT, 50% of the debt announced or the claim announced by the DRT, or it can be reduced to 25% by the tribunal. Okay, so the correct answer will be C, 1 and 2. What is the penal consequence for the borrower's non-compliance with the Section 13 restriction on transfer of secured asset? Civil liability, imprisonment up to 1 year or fine or both, imprisonment up to 3 years and fine, only cancellation of the loan facility. What will be the correct answer? When the DRT receives the application or the ARC gets the application, they will send notice to the borrower that now they cannot sell the security, they cannot transfer it to any other person, they cannot transfer the rights to any other person. Okay, if they do it, if they sell the property, they try to transfer the rights to some other person, this will be what? This will be a criminal offense. And the penal consequence of such action can be imprisonment up to 1 year or fine or both. So when the borrower receives a notice from the creditor, the borrower shall not transfer the by the way of sale, lease, or any other thing any of the secured assets referred without the notice of the without the written consent of the secured creditor, right? Non-compliance calls for punishment of imprisonment of 1 year or fine or both. Okay, so the borrower, when they get this notice, now they cannot transfer, sell, lease their secured assets. All right, which of the following correctly capture the updated penalty and adjudication process under the SURFACE post the 2016 amendment? So before 2016, for the offences and penalties, the adjudicating authority could impose fine on a company that could extend to 5 lakh rupees, and if it was a continuing offense, then 5,000 rupees for each day when the default continues. This was before 2016. You need to answer. You need to answer for the new rules. So RBI may impose penalty up to 5 lakh rupees for the non-compliance of the directions. This is the older provision before the amendment. The adjudicating authority may impose a penalty of up to 1 crore rupees or twice the quantifiable amount involved, whichever is higher. This is correct. The new provision says that the penalty can be up to 1 crore rupees, not 5 lakh. So this is correct. Third statement, yes, before imposing any penalty, a reasonable opportunity should be given to be heard to the company. And if the penalty is not paid within 30 days, the adjudicating authority will initiate a criminal, no, not a criminal proceeding. The registration of the ARC can be cancelled, but criminal proceeding cannot be initiated against the ARC. Okay, so the correct answer will be A, 2 and 3. Okay, non-payment leads to cancellation of the registration, not criminal prosecution. 2 and 3 only. All right, the correct answer will be 2 and 3 only. 5 lakh rupees is before the amendment, and non-payment within 30 days will lead to cancellation of license. According to the section 26C of the SARFAESI Act, what is the effect of registration of a security interest or attachment with the central registry? It amounts to constructive public notice from the date and time of filing. Any subsequent transfer or charge over the asset is deemed subject to the earlier registered interest. A borrower's sale of such asset in the ordinary course of business is void if it precedes the registration. If the sale is done before the registration, the registered attachment orders take precedence over the unregistered security interest, regardless of the actual possession. So, what should be the correct answer? Everyone who's present, try to answer. Also, just like the video, share the video so that others can also join. Answer this question. The effect of registration of a security interest with the SARFAESI. So whenever a charge is created, creation of charge means creation of security interest means the bank has given a loan and they have taken a security. They are a secured creditor. Registration of charge means information has been given to the SARFAESI. The SARFAESI will include it in their register that they maintain. This will be a deemed to be public notice. Now, every subsequent creditor who the borrower approaches, they should first check the register maintained by the SARFAESI. Okay, so it is a constructive public notice. Any subsequent transfer of the asset is deemed subject to the earlier registered interest. Again, correct. If it is already registered and after that the asset is sold off or transferred to another person, it can be deemed void. So they should have checked whether it is encumbered or unencumbered. However, if the borrower sells the asset before the registration, then it will not be treated as void. Okay? Sale before the registration is not treated as void. After the registration, it will be void. The registered attachment order takes precedence. Yes. The registered interest will always have priority over the unregistered charges. So if Bank A had given a loan in 2020 and Bank B had given a loan in 2021, but Bank B failed to check whether A had registered the charge with SARFAESI or not, and A had registered the charge. So now this charge will be given less priority. B will be treated as an unsecured creditor. Unsecured creditor. Okay, so the correct answer should be 1, 2, and 4. Option B. 1, 2, and 4 will be correct. Statement 3 is incorrect. Why? Because the provisions exempt transaction carried in the ordinary course of business prior to the registration. So the correct answer is B. On the publication of a notice under the SARFAESI, what is the immediate legal consequence for directors of a borrower company? When it is a corporate debtor, okay, and the notice has been issued in a newspaper that the management is being taken over by the secured creditor. Management of the company is now under the secured creditor. So what will be the legal consequence for the directors of the borrower company? They continue until the creditors appoint new directors. They remain in force but lose their voting rights. They must resign formally before vacating. They are deemed to have vacated their offices. I'm giving you 10 seconds. This is a very simple, very important question. So, when the secured creditor takes over the management of a borrower company, what will be the legal consequence for the directors of the company? Directors of the borrower company, what will be the legal consequence for them? So the legal consequence will be that they will be deemed to have vacated their office. And another point, no compensation will be given to them on account of losing their office. Okay, they are not entitled to any compensation for the loss of office or premature termination of their contract of management. So the correct answer should be D. All right, on the publication of the notice, if the borrower is a company, then the directors will be deemed to have vacated their offices. No, D. Correct answer will be D, not A. The directors are deemed to have vacated their offices. All right, and they are given no compensation. They are not entitled to any compensation for the loss of office or premature termination. All right, Secure ARC Limited, and ARC has acquired distressed financial assets from multiple banks and issued security receipt to the institutional buyers. A group of qualified buyers collectively own 80% of the total security receipt. However, due to non realization of certain financial assets, these buyers decide to invoke their rights, call a meeting to determine further actions. So, since the qualified buyers collectively hold more than 75% of the security receipt, basically, the qualified institutional buyers, the investors in the security receipt of the ARC, they, more than 75% of them, they can call a meeting, they can discuss the issues, and if any decision is taken by them, it will be binding on the ARC. So 75% of the total security receipts are held by the qualified buyers. 80%, they call a meeting, and whatever decision they take will be binding on the ARC. So if the decision is to liquidate the asset or take any other action, the ARC will have to follow it. Okay, so more than 75%, if they are holding, they can call a meeting and they can pass binding orders. What does the term appointed day refer to in relation to a tribunal or appellate tribunal? Appointed day in terms of the MSMED Act refers to the day by which or before which the payment is to be done by the buyer to the seller. In the case of the tribunal or appellate tribunal, what is the appointed day? The date on which the tribunal is established, the date on which a loan is approved, the date on which a case is filed, or the date on which a tribunal issues a judgment. Basically, the act says that wherever in the area, if there's a DRT established, the civil courts will lose their rights to hear the complaints which are under the jurisdiction. Okay? And appointed day means the date on which a tribunal or the appellate tribunal is established in a particular area. So the correct answer will be A. Why is it important? Because now the DRT is existing here. So no civil court will hear any suit, any complaint related to these cases. All right. So who establishes the tribunal? The central government establishes. DRTs and DRATs, the central government appoints the presiding officers and the chairperson. The central government determines their qualifications, the period for which they will hold office. Okay. And when it is set up, the jurisdiction, powers, and authority of the tribunal is also determined. So, whenever the tribunal is established from its appointed day, date from which they function, it is declared in a notification, they will exercise jurisdiction, powers, and authority to entertain, decide applications or appeals from the banks and financial institutions. Okay, if there was no tribunal and an order was passed by a civil court in this regard, that order will not be questioned. But after its establishment, only the DRTs and DRATs will have jurisdiction. Which of the following combinations accurately reflect the structural and qualification requirements for the DRAT chairperson? So, to be appointed as a chairperson of the DRAT, what requirements, what eligibility should be fulfilled? The appellate tribunal comprises multiple judicial members and is headed by a chief chairperson. A person who has held the presiding officer of a DRT for at least 3 years may qualify. The central government will notify the chairperson of one appellate tribunal to discharge the functions of another appellate tribunal. The maximum age of retirement for the DRAT chairperson is 65 years, extendable by the central government. So, the DRT has only one judicial officer, the presiding officer, and other recovery officers to help the presiding officer. The DRAT also has only one judicial officer, which is the chairperson. Okay, it is the chairperson. No other judicial officers are there. So the first statement is incorrect. What is the qualification of a presiding officer? The presiding officer should be competent, they should be eligible to be appointed as a district court judge. Okay, district court judge, and they will hold office for 65 years or 5 years, whichever is earlier, right? For the chairperson, however, they should be qualified to be a judge of high court and either 3 years as the Indian Legal Services or 3 years as the presiding officer of a tribunal, right? So this is also correct and this is also correct. The maximum age, however, for the retirement of the DRAT chairperson is not 65 years, it is 70 years. It is 70 years or 5 years of office, whichever is earlier, and this cannot be extended by the central government. So the correct answer should be A, 2 and 3. Make sure that you revise the qualifications of the presiding officer and the chairperson. Definitely they can be asked, right? The central government has the power. They can tell the chairperson of one DRAT to exercise jurisdiction in another DRAT due to some temporary vacancy. If let's say the if let's say the presiding officer is found to be involved in a misbehavior, some moral turpitude, or they are incapable of performing their duties, the investigation can be initiated on them. Recommendation for the investigation will be made by the chairperson of the DRT of that area. The investigation will be conducted by the central government. Okay, so the correct answer is A. Karan, a businessman, has pledged his commercial property as security from a loan from XYZ Bank. After defaulting on the repayments, the bank initiated proceedings under the SARFAESI Act and took possession of the property. However, Karan claims that the possession was taken unlawfully without proper notice, and they make an application to the DRT challenging the bank's action. Meanwhile, Mehta Enterprises, a tenant in the Karan's commercial property, also files a separate application arguing that their lease rights remain valid. So, if the DRT finds XYZ Bank's possession unlawful, what corrective action can it take? Order Karan to repay the loan immediately, require XYZ Bank to issue a revised notice, restore the possession to Karan and declare the action as invalid, dismiss the case as the secured creditors always have priority. What will be the correct answer? So, under these proceedings, if the DRT finds that actually XYZ took unlawful possession without giving notice, the corrective action that they can immediately take is restore the possession, give the property back to Karan, and declare the action invalid. They can also order the secured creditor to pay compensation for any loss or any damage that the applicant had to face. All right, so the correct answer will be C. According to the ruling in Bank of India versus Harshad Rai Odavji Modi case, what type of application can the DRT entertain? I want you to answer this question. Everyone. Execution of the decree of a foreign court, review of the SEBI regulated transactions, settlement of personal loan disputes, adjudication of contractual conflicts between the banks. What this is a very famous case, the Harshad Rai Odavji Modi. So, what was the decision taken in this case? What was the decision taken in this case? Yes, what will be the correct answer? The correct answer is that the DRTs they can execute the decree of a foreign court. So if a foreign court, basically the rights available under RDB surface are also there for the foreign. If the borrowers are from abroad, they borrowed money from an Indian bank and they failed to pay. They defaulted and a decree was announced by a foreign court. This can be executed by a DRT here in India. So the correct answer will be A. Okay. So in the Bank of India versus Harshad Rai Odavji Modi case, the Bombay High Court has held that an application for the execution of the decree of foreign court can be entertained. Execution means implementation. Okay, implementation. Which of the following statements accurately reflect the appellate mechanism under the Act? The RDB Act is also sometimes referred to as the DRT Act because under the RDB Act, the DRTs are established. No appeal can be filed before the DRAT against an order passed by the tribunal with consent of the parties. This we have seen is correct. The DRTs may entertain an appeal filed beyond 30 days if it is satisfied with the explanation. This is also true. Further extended time can be given. Once a civil case is transferred to DRT, an appeal against the tribunal's order may be filed under the Civil Procedure Code. No. Once, let's say a civil case was pending in a court, a case was pending in a civil court, and a DRT was established. The case is transferred to the DRT. The judges they think that here the DRT can resolve it, or actually the law says that on establishment all the cases they stand transferred. But now if they want to make any appeal, the appeal will be made to the DRAT only, not to the civil court. The DRAT's orders are final and cannot be challenged under any provision of the constitution. No. If the order passed by the DRAT is unconstitutional, it is unlawful, where the question of law is involved, then the borrower's aggrieved person they can reach out to the High Court or the Supreme Court directly. Writ petitions, all right. Writ petition under the Article 226 or Article 32 of our Constitution. So the correct answer will be A, 1 and 2 only. All right. Writ jurisdictions under Article 226 can be made before the Supreme Court and High Court. All right. So only 1 and 2 is correct. Statement 1 and 2. Justice Malhotra, a retired district judge, is shortlisted for appointment as the presiding officer of the DRT. Meanwhile, the central government is considering appointing a new chairperson for the DRAT. Among the candidates, Mr. Kumar, a former presiding officer of another tribunal for 4 years, and Ms. Sharma, a senior legal advisor in the Ministry of Law for 2 years, apply for the post. The appointment committee now reviews them. Who among the candidates, Mr. Kumar or Ms. Sharma, is eligible to be appointed as a chairperson? So, what is the qualification to be appointed as a chairperson? Qualified to be a judge of the High Court, served in the Indian legal services for 3 years, or served as the presiding officer of a DRT for 3 years. So Mr. Kumar, a former presiding officer of a tribunal for 4 years, they are eligible, right? More than 3 years is there. Miss Sharma is a senior legal advisor in the Ministry of Law for 2 years only. No, 3 years minimum is required. Okay, so who will be eligible? Only D. Mr. Kumar will be eligible. So the correct answer will be D. Mr. Kumar, as he has been a presiding officer for more than 3 years. Alright, so the correct answer is D. The first part says Justice Malhotra, a retired district judge, is shortlisted for the appointment as a presiding officer. Can they be appointed? Yes. Qualification is a serving or retired district judge for the presiding officer, not for the chairperson. Which of the following is excluded for automatic transfer to the DRT? When will a case be automatically transferred to the DRT from a court? Execution proceedings pending before the civil court, suits for the recovery of debts filed by the scheduled banks, proceedings under the SARFAESI Act, appeals pending before any court. So, which of the following will not be automatically transferred to the DRT? If an execution is pending, this means a court has given their order, it only needs to be executed. It will be executed by the DRT. Suits for the recovery, if any suit for recovery was made by a scheduled bank to the court from the appointed day when the DRT is established, it will be automatically transferred to the DRT. Proceedings under the SARFAESI Act will be transferred to the DRT. But if an appeal is pending in the court, it cannot be transferred to the DRT. Appeal will not be transferred. All right. Every suit or other proceeding pending before any court immediately before the establishment of a tribunal within the jurisdiction of the tribunal will be transferred. Nothing in this subsection shall apply to any appeal pending. All right. If any appeal is pending, then it cannot be transferred to the DRT. Similarly, any proceeding for the recovery of debts due to multi-state cooperative banks will be continued. It will not be transferred to the DRT. Okay. With reference to the section 21 of the DRT Act, which of the following are correct regarding the pre-deposit requirement? We have covered this question previously also. So answer it. A minimum deposit of 50% of the determined debt is mandatory to file an appeal before the DRAT. The appellate tribunal may reduce this amount to 10% on written request with reasons recorded. If the pre-deposit condition is not fulfilled, the appeal is not maintainable. The deposit condition is aimed at preventing delay tactics by defaulting borrowers. So, to make an appeal to the DRT, deposit is required. This deposit is 50%, and it can be reduced by the tribunal if they think that the borrower belongs to a weak economic background or they're facing some financial difficulty. If the condition is not fulfilled, the appeal will be non-maintainable. Correct. If this 50% is not deposited, appeal cannot be made. This is correct. But it cannot be reduced to 10%. It can be reduced to 25% only. It can be reduced to 25% only. Rest everything is correct. 1, 3, and 4. All right. 1, 3, and 4. 1 is also true. A deposit of 50% of the determined debt is mandatory. If the tribunal says, if they want, if they think it is necessary, then they can reduce it to not less than 25% of the amount determined for the reasons recorded in writing. Okay, so the correct answer will be C, 1, 3, and 4. Okay. Which of the following best distinguishes between insolvency and bankruptcy under the Indian law? What is the difference between insolvency and bankruptcy? Insolvency refers to the legal status of inability to repay debts, while bankruptcy necessarily implies criminal wrongdoing in the debt default. Bankruptcy is the legal process or declaration following insolvency, whereas insolvency is a financial condition. Insolvency occurs in relation to individuals. Bankruptcy applies exclusively to corporate debtors. Bankruptcy and insolvency are synonymous and used interchangeably under the code. So now we are talking about the Insolvency and Bankruptcy Code 2016. So what is the meaning of insolvency and how is it different from bankruptcy? There's basically two stages. There are two stages in the CIRP, right? There are two stages in the CIRP. First, we try to bring the debtor out of this insolvency situation. Insolvency means that the individual or the organization is unable to meet its outstanding financial debt towards its lenders. But if we change the repayment plan of the loan or we write off a part of the loan, then this person can be made viable again, or the organization can be made viable again. They'll be able to pay off the debt. Bankruptcy means that it is clear, it is a legal declaration that the debtor will not be able to pay whatever is done, right? So the person voluntarily declares themselves to be insolvent. So now the court will liquidate the personal property of the insolvent and hand it out to the creditors. All right. So bankruptcy leads to liquidation. Insolvency can still be solved. It can be resolved by helping the debtor overcome the temporary situation. Okay. So the first statement will be incorrect. It is not the legal status of inability to pay debt. That is bankruptcy. Okay. The bankruptcy is the legal process or declaration, correct? Insolvency happens to individuals and organizations both. Bankruptcy and insolvency are not synonymous, they are different. Okay, insolvency can be corrected by helping the organization manage better their business or any other action. They can be made viable again so that they can pay off the debt. Bankruptcy leads to liquidation, but not always a criminal wrongdoing. Only two. Only the second statement is correct. Which of the following combinations correctly match the terms to their definitions? Financial creditor, operational creditor, corporate debtor, financial debt. A person to whom a debt arising out of the provision of goods or services is owed. Operational creditor, a person whose debt arises from employment services or government dues. Corporate debtor, a company to whom a financial debt is owed by a person. Financial debt, a debt disbursed for consideration of time value of money. So, which of these statements are correct? All of the above, 1 and 3, 2, 3 and 4, or 2 and 4. What should be the correct answer? What should be the correct answer? Financial means something where money is involved. Operational means something where operations have to be done. Okay, so operational creditor is given correct. A person who owes some, who has promised to perform an activity, to do something for the promisee, to perform any action, to act as an employee in their firm. Okay, financial creditor does not mean a debt arising from the provision of goods and services. That is an operational creditor. Financial creditor means where a creditor to whom money is owed. Money is owed. So the first statement is incorrect, second is correct. Corporate debtor does not mean someone to whom a debt is owed. Corporate debtor means someone who owes a debt to the creditor. That is a company which owes a debt to the creditor. And financial debt is correct. So the correct answer will be D, 2 and 4. All right, 2 and 4. Financial creditor means someone to whom a financial debt is owed, that is, a debt disbursed for the consideration of time value of money. Operational creditor means a person whose debt arises from employment services or government dues or goods and services. Okay. Which of the following statements correctly reflect the roles and regulatory framework for the insolvency professionals and information utility? So there are four pillars of the IBC. There are four pillars. First, we have the resolution professionals. Then we have the information utilities. After that, we have the IBBI, right? We have the IBBI. And what is the fourth pillar? The fourth pillar is the adjudicating authorities. Yes, the adjudicating authorities, that is the DRT and the NCLTs. The DRTs and the NCLTs. So, which of these statements are correct? Insolvency professionals must be enrolled with an insolvency professional agency and pass the limited insolvency examination. Correct. basically basically they are responsible for the completion of the insolvency resolution or liquidation and bankruptcy proceeding. They are regulated persons, right? They are the first level regulators. A person who is enrolled as an insolvency professional with an agency, they are also registered with the IBBI, and they have qualified the limited insolvency examination. Okay, so correct. Insolvency professional agencies operate under Section 210. No, they are not tasked with adjudicating the dispute. For adjudicating the disputes, we have the adjudicating authorities, DRTs, DRATs, NCLT, and NCLAT. The role of the insolvency professional agency, we have already discussed, the insolvency professional. So this is incorrect. The information utilities are responsible for authenticating and storing the credit data. Correct. The name itself tells us to collect, collate, authenticate, and disseminate financial information, to maintain electronic database, to eliminate any delay and dispute. Okay. Adjudicating authority is the DRTs in case of individuals and partnership firms, and the NCLT for the corporate persons, the limited liability entities. The limited insolvency examination is governed by the IBBI regulation. What is IBBI? It is the fourth pillar, the Insolvency and Bankruptcy Board of India. It has the role to frame the rules and regulations, to monitor the insolvency professionals, the utilities, everything. Right? So the correct answer will be 1, 3, and 4. The correct answer will be C. Yes, the correct answer is C, 1, 3, and 4. Second statement is incorrect. The insolvency professionals, they do not have the responsibility to adjudicate the disputes. It is adjudicated by the DRTs and the NCLT. Which of the following statements accurately describe the procedural framework for the initiation of the CIRP? Who can initiate it? A financial creditor may file an application for the initiation even in respect of a default owed to another financial creditor. Can a financial creditor make an application on behalf of another financial creditor? Yes. For allottees in a real estate project, minimum of 100 allottees or 10 are required, correct? Whichever is lower, not higher, incorrect. For the allottees in a real estate project, a minimum of 100 or 10% of the allottees will make the application, whichever is lower. The application filed prior to the 2020 amendment must be modified to comply with the joint filing requirement. True. The CIRP begins from the date of filing the application. No. It begins from the date of admission of the application. When the financial creditor files the application, the adjudicating authority will conduct its scrutiny. The day on which it is admitted, it is accepted. From that day, the CIRP will begin. So the correct answer should be 1 and 3 only. Option A. 1 and 3 only. If you do not understand anything, just go through the explanations. All right. 100 allottees or 10%, whichever is less. Okay. Which of the following statements regarding inclusion and exclusion from the committee of creditors is or are correct? Basically, there's the interim resolution professional who calls claims from the financial creditors, and from them, the committee of creditors is formed. The committee of creditor then take all the necessary decisions like removal of the interim resolution professional, initiation of the CIRP, suspension of the CIRP, deciding to liquidate the firm. The committee of creditors take this decision with 66% voting or 90% voting, whatever. So the financial creditor is a related party to the corporate debtor, can never be included in the COC. They cannot be given the right to vote regardless of the regulation. No. Certain related parties are allowed. Certain related parties regulated by the financial regulators may be included. Okay. Then, so the statement should be incorrect. Financial creditor, if a creditor owes both, is owed both a financial debt and an operational debt, their voting right will be in respect to their financial debt only, correct? Because the CIRP deals with only the financial debt, not the operational debt. Okay. If the operational debt is assigned to a financial creditor, then such creditor will be treated as an operational creditor. True? Correct. An authorized representative must always be granted voting right in the COC. No. Authorized representative cannot be given the voting rights if they are a related party. Alright, if they are a related party. So the correct answer should be 2 and 3 only. Option D. Alright, 2 and 3 only. Alright. This question we have already done. Is Justice Malhotra qualified to be appointed as a presiding officer of the DRT? Yes. Why? Because he is a retired district judge. The qualification for the presiding officer of the DRT is what? It is the person should be qualified to be appointed as a district judge, or they have been a district judge. The correct answer will be A. Consider the following in light of the section 22 and 23 of the IBC. The Committee of Creditors must hold its first meeting in the 7 days of its constitution, correct? Whenever the Committee of Creditors is prepared by the interim resolution professional, they will hold their meeting, and what are they going to do in the meeting? They will appoint the resolution professional. Interim is the temporary. The same person can be appointed as the resolution professional, or a new person can be appointed with the consent. The resolution professional takes charge of managing operations of the corporate debtor once confirmed under the section 22. Correct? True. If the COC fail to reach a 66% vote, the interim resolution professional automatically becomes the resolution professional. No. If when the COC is appointing the same person or a new person, 66% of the voting should be in favor of that person and with the consent of the person. If, however, they're not able to reach, then uh, it will be referred to the adjudicating authority to certify whether the resolution professional should be appointed or a new person should be appointed. The resolution professional, once confirmed, must continue to manage the CIRP until a resolution plan is approved or liquidation is ordered. Correct. So the correct answer will be 1, 3, and 4. 1, 3, and 4. All right. So this is the responsibility of the committee of creditors. The committee of creditors. Okay. When they are deciding to start the liquidation process, again, voting should be done, right? Voting should be done. Then consider the following statements regarding the section 11. A corporate debtor undergoing CIRP cannot initiate CIRP against itself. Already a insolvency resolution program is going on. Can they apply for another one? No. So this is true. Actually, it is saying that they cannot initiate. So this is true. A corporate debtor undergoing CIRP can initiate CIRP against another corporate debtor. Yes. They cannot initiate it against themselves, but against another, they can do it. A corporate debtor who violated a resolution plan approved 11 months ago is barred from initiating, correct, if already a CIRP was initiated. But the corporate debtor, they contravened it, they violated it. Now they cannot have another CIRP before the 12-month period is over. A financial creditor of a corporate debtor undergoing the CIRP is permitted to initiate. No. If already a CIRP is going on for a financial creditor, they will not be able to initiate the resolution process against that debtor. So only 1, 2, and 3 should be correct. So the entity is not entitled to make an application. A corporate debtor undergoing a resolution process, a financial creditor of an or an operational creditor of a corporate debtor undergoing a pre-packaged insolvency resolution process, a corporate debtor having completed a process before 12 months, the corporate debtor in respect of whom a resolution plan has been approved 12 months preceding, a corporate debtor who has violated any of the terms in respect of whom the liquidation proceeding have started. All right. So the correct answer will be D, 1, 2, and 3. With reference to the evidentiary value of the entries in the banker's books and relevant case law, consider the following statements. A certified copy of an entry is admissible as evidence equal to the original entry. Now, the Bankers Books Evidence Act says that wherever the bankers' documents or books or ledgers have to be provided as evidence, original is not required, copy will be admissible. It is prima facie evidence. So, correct. Such certified copy is sufficient to fasten a civil liability on a person. Is this true? Such certified copy is sufficient by itself? No. If the entry is disputed, if the person says that the bank has not recorded the entry or the bank has recorded a wrong information, then the copy will not be sufficient. The court can order the bank to produce the original document. If the entries are accepted by the parties, then further proof of actual payment is not required. True? Correct? No further proof is required. The decision in Chandrahar Goswami versus Guwahati Bank clarifies that entries alone do not suffice unless corroborated. This means that the entries will be enough if both the parties concerned they are accepting its true value. Otherwise, the original copies can be required if the entry is disputed. So the correct answer should be 1, 3, and 4. Second statement is incorrect. 1, 3, and 4 is correct. All right. Which of the following is mandatory to accompany a computer generated printout from the banker's books? Basically, the person in charge of the computer system, they need to give another certificate justifying that the computer system has integrity, third party access is not allowed, unauthorized access is not allowed, no person can change the data, which is unlawful. So, a certificate from the principal accountant or manager confirming that the printouts represent the entry. So, along with the printout or the copy, a certificate from the principal accountant is required. A certificate from the person in charge of the computer system justifying that all the safeguards and system particulars are there. Affidavit is, however, not required. Declaration from the IT auditor is not required. Certificate from the principal accountant or manager, and certificate from the person in charge of the computer system. 1 and 2. 1 and 2 is correct. All right. So, where the books of the banks are not handwritten, they are in the computer, and the copies are taken by the way of a printout. The copy must accompany a certificate by the principal accountant or the manager that such entry exists in the original, and the certificate by the person in charge of the computer system. In a civil suit, which of the following statements accurately capture the evidentiary protocol regarding the production and inspection of the banker's books? Basically, what is the requirement of presenting the original document when the bank is not a party to the proceeding? A bank officer is legally compellable to produce original bank book in every case? No. If the certified copies are produced, no bank officer can be summoned to prove the underlying transaction unless a special clause is recorded correct. Only if the court orders, then the original documents can be asked, or the bank officers can be summoned to act as a witness. Only in special cases. So this is correct. Parties to the suit may apply to inspect the original entries. Court will allow it either with or without summoning the bank. Correct. The court will give them time that 1 hour you can enter the premises and check the entries, or 2 hours along with the fees to be paid. And a bank may object to the production of certified entries. Right? So even if the court orders the bank to provide the certified entries, the bank can show cause that there's no requirement of the certified entry, a copy should suffice. So the correct answer will be C. No bank officer can be called as a witness to prove the matters. Wherever the copies are there, certified copies are there, no officer can be compellable to produce any banker's book. Consider the following with respect to the jurisdiction and limits of the Lok Adalat. Matters pending before a court or matters not yet instituted but within the jurisdiction may be brought before a Lok Adalat. Yes, Lok Adalats are established under the Legal Services Authorities Act. If a case is directly referred to Lok Adalat, valid. If a case was pending in the civil court and the judges decide it can be solved through mediation and arbitration, it can also be transferred to the Lok Adalat. Compoundable offences under the prevailing law may be referred, correct. Non-compoundable offences cannot. Non-compoundable means wherever there is a very serious criminal offence. Civil disputes up to the prescribed monetary ceiling of 20 lakh rupees can be settled through the Lok Adalat. Lok Adalat have the power to adjudicate and issue binding decisions. No, not without the consent. Consent of both the parties is important. Let's say a compromise or settlement could not be reached in the Lok Adalat. Now the parties can take it to the civil court. If it was a transferred case, it will be returned to the civil court, and the civil court will continue from wherever they had transferred. Fresh proceedings are not required. All right. However, if the award is passed with the consent of both the parties, now it cannot be opened in any court. If the consent is received, then it will be a binding judgment. All right. The order passed by the Lok Adalat cannot be questioned when the consent has been given. Which of the following statements regarding the organization and composition of Lok Adalats is correct? Qualification of the non-judicial members of all Lok Adalats are exclusively prescribed by the central government. No. When the Lok Adalat is established by the High Court Legal Service Authority, then the state government along with the Chief Justice of the High Court will determine the non-judicial members' qualification. The Supreme Court Legal Services Committee has the authority to organize Lok Adalat across India at the places and intervals it deems fit. Correct? Serving or retired judicial officers are mandatory. Every Lok Adalat will have some retired or serving judicial officers and other non-judicial members if required. So, the judicial officers are mandatory. The state authority can prescribe different qualification for the non-judicial members of the Lok Adalat held within its jurisdiction in consultation with the Chief Justice of the High Court. True. The Lok Adalats which are established by the central authority. Their non-judicial members are determined by the central government with the Chief Justice of India. Okay, for the state authority, the state government with the Chief Justice of High Court will determine the qualification of the non-judicial members. All right. Which of the following practices would most accurately qualify as an unfair contract? So, in the Consumer Protection Act, you need to remember the difference between an unfair contract and an unfair trade practice. Unfair trade practice would mean a misleading information or a high price, right? Unfair trade contract means that the contract between the buyer and seller, it is unfair. So a telecom service provider imposes a flat 10,000 rupees termination fee, regardless of the actual usage or the remaining term. Is it an unfair trade contract? Yes. The contract says that unreasonable fee should not be imposed, unreasonable penalty should not be imposed. A furniture seller markets refurbished items as completely new. This is an unfair trade practice. Selling second-hand refurbished goods as new is unfair trade practice. The bank refuses prepayment of a loan unless the borrower pays a penalty equal to 15% of the principal, despite no loss to the bank. Unfair contract. The contract should say that prepayment is allowed and the penalty should not be this high. 15% is very high. And online streaming modifies the user subscription terms mid contract and grants itself unilateral termination right. That is, without the consent of the user, they can stop their subscription. Again, this is an unfair contract. So the correct answer will be 1, 3, and 4. All right, unfair trade practice means a trade practice which is violating the rights of the customer. Okay, unfair trade contract means excessive security deposits for the performance of the obligation, imposing a very high penalty not proportional to the breach, refusing to accept early repayment of debt, entitling a party to contract the to terminate the contract unilaterally, permitting one party to assign to the detriment of another the contract, imposing any unreasonable charge. Unfair trade practice means falsely representing the goods are of a particular standard or quality, falsely representing that they are of a particular quantity or weight, selling rebuilt second-hand goods as new, representing that the goods have sponsorship or benefits that they actually do not have. All of these are what? These are unfair trade practice. Consider the following statements regarding the state and the district consumer protection council. So there are various authorities to make sure that the customers' rights are fulfilled. Their rights are not violated. We have the consumer protection councils at the state, central, and district level. We have the dispute redressal commission at the state, district, and central level. The consumer protection authority is only at the central level. And then there is the mediation cell attached to every district. Okay. So the chairperson of the state council is nominated by the central government. Incorrect. Chairperson of the state council is nominated by the state government. The state council must not include more than 10 additional members nominated by the central government, additional members can be nominated by the central government. The district council must meet at least twice a year, correct? And the collector of the district chairs the district council. The chairperson of the Central Council, the chairperson of the Central Consumer Protection Council, is the minister in charge of the Department of Consumer Affairs in the central government. Chairperson of the State Council is the minister in charge of the Consumer Affairs in the state government. And chairperson of the District Council is the collector of the district. All right? Okay. So the correct answer is B, 2, 3, and 4. Spark Electronics, a consumer gadget company, launches a promotional campaign for its latest smart charge battery, claiming the product lasts twice as long as any competitor brand. The company fails to provide scientific tests to support this claim. Meanwhile, in a separate advertisement, the company offers 50% discount on flagship smart TV but sells only 10 units at the discounted price before going back to the full price. A consumer association finds a complaint against this company alleging false representation and deceptive trade practice. Does the Spark Electronics battery claim violate Section 2 or not? This one. First claim. No, since the customers have confirmed longer battery life. Yes, because the performance claims must be backed by adequate testing. Yes, but only if the competing brands challenge the claim in the court. No, unless the regulators demand scientific validation. So this claim that was made by them, it did not have any scientific backing. No research was conducted, no proof was there. So the correct answer will be B. It can be questioned by a consumer because it should be backed by an adequate testing. Okay, what is the jurisdiction limit for the district commission to entertain complaints? Whenever, if such question is asked, you need to answer according to the new provisions, the amended provision. So exceeding 50 lakh rupees does not exceed 50 lakh, exceeding 2 crores does not exceed 2 crore. So the jurisdiction of the district council is where the monetary amount is less than 50 lakh. Okay, less than 50 lakh. For the state is 50 lakh to 2 crore, and for the center is more than 2 crores. So the correct answer will be B. The jurisdiction of the district commission, state commission, and the national or central commission exceeding 2 crores, 50 crores to 2 crores, and less than 50 lakh rupees. 50 lakh to 2 crores. All right, so the correct answer will be B. Which of the following is included in the definition of applicant as per the Limitation Act? A judge, a petitioner, a witness, or a prosecutor. So the law of limitation and the tax law, it is not that important. Still, let us go through some questions. Applicant can be a person through whom the applicant derives the right to apply, a representative, but the main applicant will be a petitioner. Okay, so Limitation Act provides the time limit. The banks and financial institutions or the borrowers, if they want to take an action like recovery of debt, they have to file the application within a certain time period. Beyond that, not allowed. So who can be an applicant? A petitioner can be an applicant. What time is excluded when computing the period of limitation for filing a revision or review application? Basically, when we are calculating, let's say 30 days is the period of limitation. What time will be excluded when we calculate the total 30 days? The time taken for obtaining a copy of the award, for initial filing of the case, the time taken by the court to hear the appeal, the time taken for the appellate court to respond. So, when we compute the period of limitation, we are going to exclude the day on which, if let's say the court is closed, And if any appeal or application is made, then the time period for this application, the day from which on which the order is announced, that day is also excluded. Time taken for obtaining the judgment, obtaining a copy of the decree, time taken to get a review application is also excluded. Okay, so the correct answer should be A. Yes, the correct answer is A. All right, B, C, and D is not excluded. When we are calculating the total period of limitation, we exclude the time taken to obtain a decree or copy of the award. All right. What does the term previous year mean according to the section 3 of the Income Tax Act? Also, once again, revise the acts that will give fresh period of limitation. When before the period of suit or application, the payment is done. Before the expiration of the period, the payment is done, or an acknowledgement is done that yes, I am accepting my liability, I will make the payment. That will also give a fresh period of lease. Okay, so what is previous year? Previous year is the year in which we earn our income, and this income is taxed in the assessment year, which is the next year. So previous, the financial year immediately following the assessment year, the financial year immediately preceding the assessment year. Correct. So current financial year is 2025-26. The financial year 2025-26 has started. For this financial year, the previous year is what? 2024-25. We have paid our taxes in the assessment year 2025-26 for the income that we earned in 2024-25. So that is the previous year. Previous year and financial year mean the same thing. What is true about the income declared by a resident assessee in India? Now, the taxation of the different individuals or entities depend upon their residentship, whether they are a resident Indian, a non-resident Indian, or a not ordinarily resident. So, for a resident assessee, it includes income from anywhere in the world. Yes, their global income is charged. It includes only income in India. No. For the NRIs, only income earned in India is included. If it is taxed only if earned within India, again wrong. It is taxable under the Income Tax Act. So the correct answer will be A and D. Okay. So for the non-resident Indians, only their Indian income is taxed, not their global income. And for the not ordinarily resident, persons who are not ordinary resident, again, the income which is arising in India is only liable to be taxed, not their global income. So the correct answer is B. For the resident, it includes the income from anywhere in the world. What concept does the advance tax arise from? Tax deferral, pay as you earn, lump sum payment, or postponed payment. When we are talking about advance tax, advance means prior. So before the financial year ends, if I am paying a tax before that, that is known as advance, right? Advance income. And it works on the principle of pay as you earn. So how do we pay as we earn? The four installments are there. The advance tax is payable in four installments. By June 15, 15% of the tax should have been paid. By September 15, 45%. By December 15, 75%. And by March 15, 100% of the advance tax should be paid. All right. So this is on the basis of pay as you earn, self-assessment tax. When is it mandatory to code the PAN for fixed deposit or time deposit in the bank? When the deposit exceeds 10,000, 25,000, 50,000, or 1 lakh rupees? Very simple. Whenever the deposits exceed 50,000 rupees, quoting of the PAN number is mandatory, right? So fixed deposit or time deposit, opening of bank account also requires quoting PAN. If a minor is having no taxable income, they want to open a fixed deposit, then the parent or the guardian's PAN will be required. All right. Even if the banker's checks are there for some cash payment or bank order or bank check, PAN will be required. All right. So that is all. With this, we have completed our marathon for Module C. And before we end the session, you can scan this QR code from your mobile phones and you can join the Telegram channel. The Telegram channel where I am there and we are posting quizzes, polls, all the YouTube class updates. You can also interact with me if you have any doubts, any queries. So, this is the Telegram group, the official Telegram group, Oliveboard. All right. So, I will also upload it with the PDF so that you can scan it and you can join the group. Other than that, I hope everything from Module C is clear. And please make sure that you revise the Module C thoroughly. You can definitely expect 30-35 mark questions from Module C. So go through the PDF, go through the revision notes of our capsule batch, the lecture 3 and 4, which covers the Module C. All right, thoroughly you need to revise. And the acts, SARFACI Act, IBC, and the RDB. These are the three most important acts that you should thoroughly revise. Okay, so that is all for today. Tomorrow in our capsule lectures, we are starting with our module D in the morning, and then the evening we'll be having our marathon, module D marathon at 8 p.m. All right, so make sure that you attend it and you revise your module D. So thank you so much. If you have any doubts, any queries, you can let me know in the comment section. Like the video, share the video, and subscribe to the Oliveboard JIBCIB English Medium channel. And join this Telegram group as well. So, thank you so much. Good night. Take care and all the best.